Mark, first to you. You're a defense attorney. What are we supposed to do with this case? This is just disgusting. No?
Well, clearly. I mean, I'm a father of 3. I've been in the criminal justice arena for 20 years. I've actually defended cases like this, but this one stands out to me as the most abhorrent that I've ever heard of. Well, the one thing that makes it more disturbing is that the facts are not in dispute. You know, at least in Casey Anthony, we couldn't exactly see how it all went down. We figured we knew. This we know exactly. It's just why she did it. And what they're going to do, I think this is a slow guilty verdict, ultimately, in my opinion. Generally, these insanity defenses don't work. Fact specifically, this defendant gave numerous stories. At one point, she told law enforcement that she dropped the child on a heater. So in one respect, she's saying that she blacked out and had absolutely no idea, no recollection. It was automatic conduct, but yet she knows specifically how it happened. Yes.
Right. We're looking at the baby here while you're speaking there. I want to remind people that not at the arrest, the warrant shows that she failed a polygraph test. She seemed deceptive. And at one point, she told investigators that she might have a split personality. Are we just sort of spitting game here all over the place? Any psychiatric diagnosis that might account for a dissociative state where people do bizarre things?
Well, let me say this, and I'm not defending her. I did get a surprise call from her defense lawyer tonight. Apparently, she found out from your bookers that I was going to be on, and we spoke at length. And what she's saying, for what it's worth, she believes that her client really does suffer from this seizure disorder, and that there are experts, one apparently on the state's witness list, that's going to corroborate or support that she does suffer from this, allegedly. That while she's going through it, I know you don't want to hear it, but that's what they're going to allege.
All right, well, here is Kay Yang's lawyer herself talking to a reporter about the physical and mental state of her client. Take a look at this.
There is certainly concern about her medical condition. I'm obviously not at liberty to talk about her medical condition, but she has many medical and as well as psychological issues that need to be addressed.
Dr. Upgrove, I want to head out to you. You've actually done studies on the damage done from microwave. I mean, I hate to ask this question, but every time I mention this story, people went, oh my God, what happened to that child? So what happened to that child in the microwave?
Well, the case that I had was different in this case in California in the fact that this child here in Dayton was not reportedly found in a microwave oven. She presented to the local children's emergency room, which because of the heinous nature of this case and how incredibly rare it is, it was much more difficult to determine, from the onset exactly how this child had sustained these kinds of burns. And after ruling out the obvious as far as being in a house fire or automobile fire, electrocution, boiling water, having being dunked in a bathtub, after all those things had been ruled out, we subsequently were able to determine, based on the baby's DNA, which was subsequently recovered from the microwave from the residence, that she had in fact been placed in a microwave oven. And some of the literature that was present at the time documented there were some cases of some children who had been abused by being placed in a microwave and sustained burns, but at that time we were unaware of any fatalities. But there have been extensive animal studies showing the effects of microwave radiation on living tissues.
And my understanding is that the autopsy of this child, the one we're talking about here, who you were just seeing in that picture a second ago, was that she actually had thermal, burn injuries to her stomach and intestines. So she literally, I don't want to even think about this. This is, Mark, help me out with this. I mean, she changed her story. First she said she dropped the baby on a heater, and then she conveniently developed some sort of seizure. Now, let me be clear. There are seizure disorders, something called partial complex seizure, that can cause people to do repetitive things and not know what they're doing. They usually don't do purposeful things like putting something in a microwave and turning it on. I'm choking on this story. It's disgusting. Do you think that she's going to have any leg to stand on with that defense?
No. That's the short version, no, for a number of reasons. Generically, this defense just doesn't work in general. Someone tried like a sleepwalking defense. Jurors don't want to excuse abhorrent conduct like this, and these jurors are going to hear the fact that the child's body was burned 80%, that the internal organs were essentially cooked, and as graphic and as gross as that is, that factors into why this defense is not going to work. They're going to be so primed to want to strike back at this woman, no matter how much they say they can be fair and impartial, that when the mental health stuff comes in, I think they're going to dismiss it.
I have some Facebook comments. Listen to this. Our website lit up with this story. I think she's full of it, it says. I think we, the taxpayers, should throw her butt in a microwave and save our money from her court costs. Carrie's also a comedian. Also, here's another one. I literally just said, what out loud? What is wrong with people? That is from Kelly. I mean, people don't want to hear this kind of a defense when there's this kind of egregious, purposeful behavior. Question to you, Mark, is should this be a death penalty case?
Well, let me answer it this way, because I want to avoid the hate mail. Trust me, I got it before I came on. People really want this woman to fry. I could tell you this. I defer to the prosecutors who, like prosecutors throughout the country, do a balancing test as they would have jurors do. The reasons for, meaning aggravators, versus the mitigators. And they determined on their own that the aggravators, the fact that this was especially heinous, atrocious, and cruel, and then the mitigators, things like she's never harmed a fly, allegedly, she doesn't have any prior record, that on balance, it tipped in favor of not seeking the death penalty.
What? Mark, I thought for sure you were going to say something different. On balance, it doesn't matter if she's harmed a fly.
Hold on.
She's
hold on.
Throwing a baby in the microwave.
Excuse me. I said that the prosecutors came to that understanding. I didn't say that was my personal belief. I will withhold that.
Got it.
Because I am filled with love. I want nothing but love emails. I don't need that.
Yes. I heard about that last night, Mark. Thank